let me move on to the second issue. Second issue, I've already touched on it, it's confidentiality agreements. It seems like these days almost every employee has a confidentiality agreement. Maybe not a non-compete always, but almost always. If there's any written employment agreement, there's probably going to be a confidentiality clause in it. I've put a sample one up on the screen. It's kind of small print, but you've seen these before. Typically, it defines just about everything the company has as confidential. There's usually some laundry list like this one, you know, where they say software source code, business methods, technical methods, processes and practices. Just everything that the lawyer who drafted it could think of that they might want to protect as confidential information. And another thing that these clauses typically have is a provision requiring the return of company information when the employee leaves. And I've got an example of one of those. So it talks about promptly upon conclusion or within 3 business days after request, all copies of the confidential information, and then it goes on, will be delivered by the recipient to the disclosing party. Okay, so let's say you're representing an employee who has left, and you've pressed them about the confidential documents, and the client says, yeah, I do have some of the company documents. I don't think they're trade secrets or anything, but yeah, I have some of these. And you get a demand from the company's lawyer saying, citing this clause and saying, hey, you need to return these files. Do you see any problem with that? Returning the files or deleting the files? Let's say they send you a demand and they say, you need to return these documents and delete any and all copies that are on your devices. Does doing that present any problem? I think it does. What's the problem with that? Anybody? Well, there's a couple.
Isn't that your evidence?
Yeah, well, that's your evidence, for one thing.
Giving it back is good.
Yeah, say that again.
Giving it back is good faith compliance.
Yeah, giving it back is good faith compliance. It's the evidence. I think there are 2 problems with it. One is that, what about the duty to preserve relevant evidence? You've got a common law duty to preserve, so the employee has these documents and somebody's demanding that the employee delete them to comply with the confidentiality agreement. It sets up a situation where you may have conflicting duties between what the contract requires and the common law duty to preserve evidence. So that's one problem. A second problem is more of a practical problem, and that is that if you're the lawyer representing an employee, that may be evidence you need to prove your case in the subsequent lawsuit. That's especially true when you have a situation where the employee claims compensation that is still owed, such as a commission or a bonus that the employee says, they still owe me these commissions for sales that I made just before leaving. I had a case where my client was owed a substantial performance bonus, and this very issue came up, and we made the decision to keep certain documents that he had taken, which proved, in our eyes, that he had met the milestone required to get his performance bonus. And I remember the lawyer for the company at some point said the company was a little irritated when they found out that he had taken these documents. And I said, well, I understand, but one reason he needed those because they were evidence to support his claim. And she said, well, yeah, but you could have returned those and then asked us for them in discovery, right? And I wanted to be sarcastic. I was thinking to myself, yeah, right. Because a big multi-billion-dollar international company trying to avoid paying a bonus to an employee, they would never, be obstructive or make us spend thousands of dollars on motions to compel to get these documents. No, that would never happen. That's what I was thinking to myself. But I was nice about it. But you see the problem. Are you sure that you can really trust that if you send those documents back that you're going to get all of those documents in discovery? You should, but I'd be a little concerned that maybe I would. So that's the practical problem, I think, with this issue of returning company documents. So these doors represent decisions. And so the point really here is that when you're in this situation where the company is demanding that you return or delete documents, you've got a number of decisions to make. On one end of the spectrum, you could just simply comply, do exactly what they ask, send the documents back, delete the documents. One practical problem with that is, what does it really mean to return an electronic document? You know, how do you really return a document in electronic form? I mean, really all you can do is just send back a copy and then delete the one that you have. So this returning can be a practical issue. So that's on one end of the spectrum. So that might be one of these doors. On the other end of the spectrum, you could simply say, no, you know, we're not doing anything. We're not returning anything, we're not deleting anything. This is evidence we need, so forget it. The problem with that is that you're setting the client up for liability for a breach of that clause, right? And that can be a problem. There's a sort of middle ground, and I would say that this is probably a good practice in most cases. If you're concerned about these issues and you don't want to just return everything, a middle ground is you could have an expert make a forensic image of the device at issue. So let's say if it's a hard drive, have a forensic image of the hard drive made, and then you as the lawyer, you say, okay, I'm going to keep that in my file in my office. Employee is going to delete anything he still has on his personal devices, and then I'm going to send a letter to opposing counsel and tell them exactly what we've done. And probably offer to make the forensic copy available, or at least to, you may not be able to make the entire thing available, but basically to let them know, look, we're not trying to hide evidence here, but we can't just comply with your request to delete everything, because then we would be violating our duty to preserve evidence. So my practice tip on this issue is exercise judgment about deleting or returning documents. There really isn't any one-size-fits-all solution for this issue. You've got to think through the pros and cons and discuss that with the client. The case I'll recommend to you that deals with confidentiality agreements is a case called Dougherty versus Highland Capital Management. This is a departing employee case in the Dallas Court of Appeals that involved a financial advisor. So a financial advisor leaves the company that manages people's wealth, starts up a competing company, and gets sued for breaching his confidentiality agreement. And what's the breach? Well, part of it is the company says, we sent you 2 cease and desist letters demanding that you return this confidential information, which included things like the company's investment strategies, present and future investment strategies. So some pretty sensitive stuff from the perspective of the company. The employee refused to return the documents. So there was a big fight. The case eventually goes to trial. And there is a question submitted to the jury on, did the employee breach the confidentiality agreement? The jury answers yes. So yes finding on liability for breach. Then there's a damage question. On the damages question, the jury finds 0 damages for the breach of the confidentiality agreement. And sometimes this is your best defense if you're on the defense side of one of these situations. If the employee just kept the information but didn't do anything with it, if it's just sitting in a drawer, you've got a pretty good argument that even if it's a technical breach, it didn't cause any damages. So apparently that was the type of argument made in this Highland Capital case. Okay, but the trial court judge decided to grant a permanent injunction. So you gotta remember, it's not just damages, and the injunction barred the employee from using any of this confidential information. Okay, now is there any other kind of relief you can think of that trial court judge might have awarded for breach of the confidentiality agreement. No damages, entered an injunction. What else could, what's that? Ray?
Specific performance.
Specific performance, yeah, actually, well, I guess an injunction is.
No, I'm saying to return it up.
Right, the judge, that's true, the judge could enter an injunction or an order of specific performance saying, return the documents, as opposed to just don't use them. Yeah, that's a good point. And that may be something you want to ask for if you represent the plaintiff company. Well, there was one other form of relief, and that was attorney's fees. All right, anybody want to take a stab at what the amount of attorney's fees was? 2 point, yeah.
Well, it has to be proportional to the damages.
The attorney's fees, he said, the attorney's fees has to be proportionate to the damages. Makes sense to me. And but the damages were 0. What's proportionate? Well, the judge awarded $2.8 million in attorney's fees.
You can stand up.
And it stood up on appeal. Somewhat surprising. Now, I have a feeling part of that was there must have been, the employee must have fought so hard throughout the course of this litigation that it really drove up the amount of the fees, right? But still, that's a lot of fees, especially for a 0 damages case. So what it tells you is that when you're exercising judgment about the confidentiality agreement, keep in mind, even if there are no damages, there could be attorney's fees. Questions, comments about that issue? Anybody? Has anybody ever been in this situation where you either sent or received a demand to, and I won't call on you, I'm just curious, sent or received a demand to return company documents? Yeah, quite a few of you. I think that's a pretty common situation.